Well, welcome to tonight's class. And of course, we're going to be working on the quiz and the material for the modulars that you've been working on with regard to students and student rights. And as I was saying previously, this particular section or these sections, these modulars, but particularly for aspiring principals, is critical that you have an understanding of this because you work more closely with students. And in the meantime, I've been told by my previous students that many of them did not have a law class in their undergrad. And they said, geez, I wish we would have had a law class because knowing this stuff would have helped. And I think that it does. So the first thing I want to do is kind of touch base with you regarding upcoming assignments. And of course, you have case study 2 coming up, and that's going to be over these next, the modules that we're working on, the student modules. And the last discussion, or the next discussion, I should say, well, and it's the last one as well. You guys have done extraordinarily well with the way I'm asking you to provide that information. You seem to be really getting it. You really zoom in on the good stuff. And of course, this case study, as you recall, will have a number of things linked together because in generality, that's the way schools operate. These law things don't operate in isolation. They operate simultaneously. So are there any questions on those upcoming assignments? Okay. So the administration wanted me to remind you about the submitting your evaluation for the course. And you do that by going to my portal and submitting that information. I think that you can do that up until the end of the course. Not sure about that. So wanted just to remind you of that. So let's get into this, okay? And I hope that I'm going to spend a little bit of time talking about each one of these cases because they're so critical. And one of the things I think that I hope that you've realized is that we evolve. And prior to this first case, there really weren't any challenges legally that was going on in education much. Teachers did whatever they wanted, administrators did whatever they wanted, and that's the way it operated. And then starting probably in the 60s and maybe into the 70s, that's when we started to see litigation and things going to ultimately the Supreme Court, which are the ones that we're looking at, those landmark cases. The first one is a First Amendment case, and I'm going to see what you can recall from this, okay? And then and I'll provide the emphasis. The Tinker versus Des Moines case. What can anybody recall what that particular case was about?
Was that the one with the armbands where the
Yes.
students wore the armbands to support,
Vietnam.
yeah, Vietnam, and then it was
Actually, it was against Vietnam. It was they were protesting against Vietnam. Yes.
and the school said that they couldn't wear it,
Yes.
but they argued that it was free speech. It went to the Supreme Court, and they decided that as long as it was not disrupting school environment and promoting violence, that they could wear them.
I am very proud of you. You nailed that right on the money. It established substantial disruption. And what these kids did is they just wore the armband. They didn't demonstrate. They didn't cause disruption. They just wore the armband. The school, and once again, take us back into that long time ago, administrators were used to doing what they wanted to do. And so therefore, they suspended them. Well, didn't work. So very good analysts of that. And you can see why, and that plays big time on discipline kinds of issues in today's world, okay? So if there's not that substantial disruption, and of course that's a legal definition of that, then you've got to walk away, okay? So the next one is Bethel versus Fraser. Can anybody recall that one? You're kind of smiling. Yeah, it's kind of funny.
Yeah, the Supreme Court ruled that the school had not violated the First Amendment rights and that they do not have to tolerate, what is it, lewd and obscene speech.
Absolutely. So the kid got up and he gave a speech, and it was lewd and vulgar, and the schools took disciplinary action against him, and bingo, the Supreme Court said, no, that is not protected speech. So one of the things that we weigh is whether a person's right to speak or whether they do not have the right to speak, because there are limits on our speech. Of course, you probably learned you can't yell fire in a theater when there's no fire. You probably did that when you're in junior high school, I suppose. The next one is Hazelwood versus Kuhlmeyer. How about Ezra? Can you give me that one?
Yeah, I'm looking through my notes right now because I can
That's
remember the
fine.
name, but I can't remember it off the top of my head.
Okay.
Um,
Can anybody help?
Yeah, the Supreme Court held that schools can restrict what is published in student newspapers if the papers were not established as like a public forum.
Yes, exactly. Yeah. So you guys are hitting on all cylinders. And this is what I've found is this is the way the school law course works. Kind of muddy with the teacher stuff, kind of muddy. And it's kind of foreign also. And then we get into this part, and when you have a good base, a good foundation, it makes sense to you. You see, and of course you see it in schools as well, which helps. And yes, the Supreme Court determined the definitions of a closed form and an open form. And of course, if it's an open form, then anything can be said. If it's a closed form, you can't. And that's what was going on here. This was a closed forum. Okay. So how does this play in today's world? If you have students do papers, you have them do a blog, you have them do things like this, and you don't tell them straight up, you cannot write anything that comes to your mind. Therefore, what you've just said there is this is a closed form, kind of like your classroom. This is the reason you can control kids in your classroom, because it is a closed forum. And so therefore, but if you don't say that, it could be interpreted as an open forum. So keep that in mind when you give assignments and those kinds of things. You know, the other, I don't know if I think I might have said this. You don't have, you ain't got a problem till you got a problem in school law, meaning that, you know, you can violate the law, but if nobody calls you to question, well, you ain't got a problem. But you got a problem when somebody calls you to question. Okay. Okay. These next, those are major cases. Okay. These next are, many of them are not quite as vital, I guess, but still have importance. Blah versus Fort Thomas. I thought you might not recognize this. In this, it was talking about school dress code. And the kid's father was a lawyer. That was always causes you trouble when you're in schools. And the Sixth Circuit held that the dress code did not violate her First Amendment rights to freedom of speech, freedom of expression. Since this time, schools have gotten, and I'm okay with this, more and more relaxed with regard to dress code. You know, maybe, particularly in a Catholic school, length of skirts, something like that. Yeah, kind of okay. But on average, people don't, you know, bother much. Now, obviously, if they're wearing something that's extraordinarily attention-getting, there you go. Now you take action. Okay. This next one's kind of humorous. Morris versus Frederick.
This is the strangest thing I've ever seen. It's that high
funny.
school. It's
absolutely
funny.
Right.
It is. The high school student was off campus and there was the Winter Olympic torch relay, and he had that banner that said like "bong hits for Jesus" or something like that. And
Absolutely.
I guess it violated Tinker, the
Uh,
decision from Tinker.
Yes, and this the school principal got away with something, I think, because she was ultra aggressive. She was I mean, first of all, he skipped school. That's number one. Okay. Always look at the fact pattern. He skipped school. Right there, you got a problem. He was on the other side of the street, okay, and unfurled the sign. And obviously, the attendance was considered part of a school supervised activity, and so therefore, boom, he got in trouble, and it was upheld by a thin 5-4 vote. So, that's something you always got to be somewhat watchful for with Supreme Court cases, is how there's votes going on. Okay, next one, extremely important case, New Jersey versus TLO. L, you with me?
Oh,
Yeah,
I'm
I'm
sorry.
here. I'm just trying to look through my notes.
Oh, okay.
Yeah, and I'm attending from my phone, so it makes it more challenging for me to
Oh, okay.
unmute. Yeah.
Well, Ezra, did you want to answer it?
Yeah, I remember this one. This was where the student had, or she said she wasn't smoking, but then the assistant principal, the other student said that no, we were. So the principal took the purse, she found the cigarettes, and she found all this paper. She found all of this stuff. TLO
Here she was dealing drugs
Mhm.
on top of, and in
Yeah,
this,
she had the list of names, I remember, of like
yeah,
the other students she was
but
gonna sell to.
everything that the drug dealer does, I guess.
Mhm.
And so, you know, to some degree, the principal got a little bit lucky, in my opinion. Well, first of all, here's my suggestion in searches. And you're right. The court established that there was reasonable suspicion for the search, and that is the standard you must go by. Here's always my suggestion with searches. The first thing you should, obviously, you have the student, you, and probably a witness in the room together. And if it is something that's in a purse, you ask the student if they will empty their purse. Now, they're volunteering to empty it. So that really helps as far as the search is concerned. But if you still have strong, reasonable suspicion, yes, go in the purse and check to see what you find. Like I said, I think the principal got a little bit lucky here because it was so dramatic what he found. Had he just found the cigarettes, I don't know. I mean, I'm not going to say that, different time, different set of circumstances, but either way, it established the process for the search. And the text does a pretty good job of giving you some criteria for thinking about searching. I mean, if you're looking at an elementary child, a kindergartner, for example, you don't rough them up, you don't scare them, but yet you do what you got to do. If you're dealing with a high school student, it's a little bit different territory. You can be a little bit more aggressive. Okay. I'll stop here for a second. I'll give you a little bit of one of my situations. So I'm a principal, and one of my assistant principals brought me a little tab, and I know nothing about drugs, and so but I knew it wasn't normal. And the teacher said that he was going to put it under his tongue. So at that particular point, it was getting near the end of the day. That particular point, I suspended the meeting and I said, I'm going to have this substance looked at by police authorities, and they're going to advise me what this is. And we will reconvene our suspension hearing the next day. And I thought, well, maybe the kid won't show up, but he did. And so lo and behold, it was laced with LSD. We I recommended, in Ohio, a little bit different than Michigan, I recommended a 10-day suspension, or I mean, I took a 10-day suspension, which is what I could do as the principal. And I recommended to the superintendent to expel the student, which he was. So to go into this a little bit further, my superintendent I was probably a second-year principal, and he was very helpful in guiding me. And I think I already told you, whenever there was a suspension, he made me tell him what was going to happen before I took action. By this time, I was a second or third year, so I was a little bit more schooled. But he did a thorough examination of what happened. And the teacher did, in fact, take the substance from the student, and he took it by himself to the principal. The principal brought it to me. I took it to, or had it taken to, the police. As my superintendent advised, fortunately, we didn't have a problem because all the lawyers, there were 2 lawyers that showed up. All the lawyers wanted to do was just get him, they didn't want him to lose school time. Of course, expulsion, you lose school time. They lost. And so anyway, my superintendent debriefed me, and he said, it's a darn good thing that they didn't ask me about chain of custody, because what could have been said at a number of junctures is, who said we didn't plant that on him? Now, we didn't have a problem, so thank God we didn't have a problem, and it got taken care of. So the other thing that I think it's good for me to tell you this, the difference between being a principal and being a superintendent. As the principal, you've got to react to things, and the superintendent has time on their side. They can go a little bit slower, maybe go a little bit deeper, and do a little bit more digging. And so anyway, that's that. This next case isn't too important, but I wanted you to hear it. Doe versus Renfro. And this is about canine searches. And we've kind of been all over the place with canine searches. In most cases, they've been upheld, but it kind of depends on what goes down. I'm not sure schools are doing those that much these days, maybe. Then the next one is Schomburg versus the state. And this was a car search, and where contraband was found, and the discipline was upheld by the court. I had a case of this as well. One of my students came to me and said, Mr. Bourne, I wasn't a doctor at the time. He says, Mr. Bourne, someone stole my CDs. That's back in the CD days. And I said, stole your CDs? What do you mean? He said, well, he said, I have lots of CDs. And he says, I looked in a car, and I saw my CDs there. This person stole my CDs. I said, oh boy. So, and this was, interestingly enough, this was during summer school. I was a summer school principal. And by the way, adding to this, students have less rights in summer school than they do regular school because they opt to be in summer school. So as a result, I had time in this case. I called the police, and myself, the police officer, was at the car when the student was released to go home. And at that particular point, the police officer asked the kid to open up his trunk and open up the car and explain the CDs. The kid did it. Ultimately, once again, I'm not bound by as many restrictions in summer school. I told the kid, just don't come back tomorrow, you're done. He says, what about my fee? I said, well, you just lost it. And from there, the police office took the results. The kid eventually got his I mean, hundreds of CDs back. So it won't happen today because you're not dealing with CDs. Everybody's streaming or whatever. Anyway, Verona School District versus Acton and the Thompson versus Carthage case. Both of these are drug testing for athletes. They were upheld. And if you have a tight athletic code, which by the way, that handbook is law. You can do those if you choose. Link versus Northwestern, random drug testing without suspicion was found unconstitutional. Got to have suspicion. Ingram versus Wright. Students always find this one a little bit humorous in today's world. Still on the books, by the way. Well, that case is a corporal punishment case. And it was upheld. And even today, well, I should back off. Many states have banned corporal punishment. Many states have banned corporal punishment. Not sure about Michigan, Ohio. Ohio did years ago. But as far as the federal law is concerned, it still could be done. The next one is an extremely important case. Goss versus Lopez. Can someone give me the details about this one?
I have this one.
Go ahead.
This had where the principal suspended in Ohio for up to 10 days without a hearing, but there had to be the 24-hour notice. And then it was 8 steps that you have to give the students, the Supreme Court said, before you do all that. So the notice of charge, prior notice of hearing, right to a fair hearing, 24-hour notice of writing, legal counsel at all stages, appealing, calling of witnesses, and cross-examining.
Bingo. And you see why this is so important today. Because if you are going to, well, let me back up. Can you imagine a world where principals just told kids, go home, you're out of here for 5 days? I mean, that's hard to even think about. But that's the way it was. But of course, nowadays, if you take that disciplinary action, you have to follow all those steps. The one that is different from state to state is being able to cross-examine witnesses. Some states don't allow that. Other states do. I can't remember what Michigan does. Ohio doesn't allow it. And I'm kind of glad they don't, because you got kids talking against kids, and I never tried to pit a kid versus a kid. I might do it in private, but I wouldn't do it in public. And of course, this was a suspension without a hearing and violated the due process clause of the 14th Amendment. Okay. Franklin versus Gwinnett. What a sad, sad case this is. Title IX case. And has lots of importance in today's world. In this particular case, a teacher was sexually harassing a student. And the administrators knew about it. They did nothing. They did nothing. And that's why it becomes so darned important in today's world. So the court rule of this was the very, very first case that they gave money to the family as restitution or relief. And it established deliberate indifference, important words, deliberate indifference. And so therefore, if you have someone come to you and tell you that a child is cyberbullying them, you have to do some investigation. You are advised to do some investigation, because if you don't do some investigation, it could be determined that it would be deliberate indifference, administration not doing anything. There's lots of sad cases. In Ohio, a girl was being harassed, bullied for a variety of, I won't go into the details of the case, but just say that she was being bullied. She killed herself. She killed herself. The parents felt really bad, but also knew that the school knew about it and didn't do enough to help their child. And so they sued the school district and won. And in fact, there's a cyberbullying law that's named after this particular person. Okay, we got through those kinds of things. The next one is recognize the standards, and you guys did this pretty good. Recognize the standards and situations in which administrators and teachers may restrict a student's free speech rights. The first one is the Tinker Standard. Remember what that one is? Teresa told you.
The was it? I can't remember the words now. Meaningful disruption or substantial disruption.
Material and substantial disruption. Yes. Okay. You know, one of the good things, our quizzes are multiple choice, which really, I think, helps you to some degree. You don't have to bring it out totally. The Fraser Standard.
It indicates that schools may limit expression if it is offensive, vulgar, or lewd, as Fraser's speech was intended to be.
Absolutely. You know, I've often advised students that, you know, if a kid, you know, kids can be kids, I guess is the best way to put it. And so the kid spouts off and uses foul language, and you take steps to correct them. And the kid comes back at you and says, blah, 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 blah. And that's when you come back to them and say, oh, wait a minute. I don't think you are aware that your free speech right is limited. And here's why. And that backs them down pretty quick, really. The Truth Threat case, and that was Virginia versus Black. And it established that's another one of those restrictions on free speech. You can't threaten people. Okay. Some of this, I think some of this is common sense to some degree. Okay, the next one gets into students' property and liberty rights, as well as substantive and procedural due process rights. And of course, you guys did, Ezra did a great job of identifying what those specifics are. And you know, so one of the things I did as a principal is I had little things like this on, of course, today I'd have it on my phone, but on an index card so that I could pull it out to refresh my memory. You can't keep this stuff in your head completely, and that's understandable. Of course, property rights mean that the students have a right to an education. That's why you just have to give them due process if you're going to suspend them or expel them or take that right away for them. Less important if you are doing after school or detentions. You know, if you're doing a lunch detention, you know, the due process is very, very limited, low threshold. Obviously, the higher the action, the more it is. Liberty rights, that means the right to travel, pursue happiness, things such as that are liberties. Substantive, the interesting difference between procedural due process, which is easy to understand, got to go through these steps, as opposed to substantive due process, which is a little bit harder concept to grasp. Substantive due process is the notion that due process only protects certain legal procedures, but also protects certain rights unrelated to procedures such as life, liberty, and pursuit of happiness. I know that's probably as clear as mud because it's about as clear as mud to me. I think it's a difficult concept to grasp. I don't think I have any questions on substantive due process, but those are the key things. Now we get into distinguishing the difference between probable cause and reasonable suspicion, extraordinarily important for searching. Can somebody give me some information on that?
I remember that probable cause for you, like do any type of search, you have to, it has to be the warrant first to be able to do that.
Well, you said the right word, warrant. Okay. You were a little bit cut out there.
Sorry, I got flashed and my internet was unstable.
Yeah, that's okay. But you're right. Probable cause is the standard that police authorities must adhere to. They have to obtain a warrant before they arrest a suspected criminal. Back to that case I was telling you about, the kid, amazingly, I don't think that the cop, I'm pretty sure the cop didn't have a warrant to go into that kid's car. Now, the kid didn't know that, I don't think. And so, and when the kid voluntarily opened it up, that took the probable cause and the need for a warrant off the table. Of course, school districts are reasonable, and thank God for this, reasonable suspicion. If there's just suspected misbehavior, you have the right to investigate, you have the right to search, you have the right to do those kinds of things. Courts have been fair to schools in general, and there's a good example of, I think, they're fair, okay? These other cases are dealing with technology, and I'm going to rattle through them pretty quick. And so that kind of tells you they're important, but yet, not as important as those others we were talking about. Dwyer versus Oceanport. This was an 8th grade student, had a website called I Hate Maple Place. And so we were dealing with a forum here. And he had a guest book. And he said, if you want to post something, you have the right to post it. And of course, the school found out about it. The school took exception to it, and they suspended the kid. And ultimately, and here's something else you need to hear. Oftentimes in these cases, particularly as they go toward the Supreme Court, they're costly. And so there are groups that help fund the legal charges. And the ACLU is one of those groups that are working to broaden the scope. And in this particular case, the school district had in fact violated the students' rights. The next one is a group, and I think I'm just going to do this. I'm just going to say that I found this quite interesting because I was teaching as technology was becoming a thing. Many of these cases are now on the books. When I was in that process, we were exploring the rights. We were exploring the various kinds of things. And we now have a pretty good feel for where we are with those kinds of things. The one that I find kind of interesting, and by the way, the school did a marvelous, this is good administrative work. And this is Doninger versus Niehoff. And Doninger she was a good student. She had heard that the district was going to cancel a school dance that she had worked hard to organize. When she heard this, she used the school computers to get the message out to parents and ask them to get on top of the administrators. The cool thing that the administration did here, and many times taking a lateral move is a good move rather than charging straight at. In this particular case, they took no disciplinary action against her, but they told her, you can't run for school secretary. And running for school secretary was a privilege, not a right. And so they didn't violate any of her rights, and the court upheld those actions. I'm flipping through some of these. I always have to tell this case because this is absolutely hilarious. This case is a Fourth Amendment case, and so it's a search case, and it also gets into searching cell phones, which is today's world. Klump versus Nazareth Area School District. I call this case Dumb, Dumber, and Dumbest. Here's why. First of all, and remember, some of these things are evolving. And so this school had no cell phone policy in its student handbook, in its board policy, And once again, today's world, you probably all have those kinds of things in place. Well, Klump had his cell phone, wasn't supposed to have it, it fell out. The teacher took the cell phone and took it to the principal and asked the principal to search the phone. That's dumb, okay? Where's the reasonable suspicion? You know, once again, back to those earlier cases. Well, dumber searched the phone. And interestingly enough, they did find some stuff in there, but the court didn't like the way this was done. And dumbest was the school superintendent, because dumbest went on record with a newspaper to say this kid was a drug dealer. And he was asked, well, what gives you the authority to think that he has, you know, are you a, you know, law enforcement person? Are you a blah, blah, blah? And the answer is no. The circuit upheld, there was a lot of parts to this case. The circuit court didn't get to the Supreme Court. Circuit court upheld the cell phone, taking the cell phone, that was okay, but they obviously did not uphold the search. And the Klumps got a monetary relief from there, okay? One last one of these. Robbins versus Lower Merion School District. Not sure if you know, I'm getting into the weeds here a little bit, and I understand that. I just want to kind of review these. So in Robbins versus Lower Merion, now, once again, first of all, Lower Merion is in Pennsylvania, an extraordinarily wealthy school district. And they gave, and this, I can't remember what year this was, probably 80s, maybe 90s. Every student was given a laptop, okay? And, you know, that's pretty common in today's world, but back then, not so common. Well, the principal, and they had cameras on them. The principal brought the student into his office and confronted him because he saw him, what he thought, he was watching the kid, privacy, yeah? Yeah, he was watching the kids, and he contended that the kid was taking drugs. Long story short, the kid was not taking drugs. He was, it was some sort of candy. I can't remember what it was, some sort of candy. Obviously, and a number of other students got in on, families got in on this case as well. The students won the case, and the school district those families were given a healthy settlement to have this case resolved. So once again, I mean, common sense tells you not to be prying on kids in their bedrooms involved. I mean, there was a couple of girls involved as well. Anyway, getting back to the next one, and you guys have already pointed these out, so I'm not going to spend much time understanding the difference between a closed and open forum. I think you've got all that, and you know how that deals with student-supported, student-created work, because that's where it comes into play. Know the procedure regulations and the differences between after-school detention, out-of-school suspension, in-school suspension, and expulsion. One of the things that I found interesting in examining Michigan law is principals have the authority to expel, and boards have the authority to expel. I found that a little bit interesting. Not sure how that plays out in real. In Ohio, as I already told you, principals can take a maximum of 10 days. The superintendent has the authority to expel, and the Board of Education has the authority to review and appeals in those cases. Suspensions, superintendent appeals, expulsions, Board of Education appeals. Okay, next is to be aware of the search and seizure situations, which you already talked about, regarding reasonable suspicion, lockers, cell phones, student desks, and automobiles. Realize your federal and state statutes related to bullying, cyberbullying, and sexting. you know, we are at a time where we're pretty evolved with this now. You know, we've had situations and states have passed laws that are on point with those kinds of things. Okay, understand the purposes of the student code of conduct and the acceptable use policy. One of the things you're going to be doing is you're going to be looking at your student code of conduct. And we're going to be asking you, does this have this in it? And you'll mark yes, no, it doesn't, and give a comment. And also, I think I'm asking you to be specific about what law is part of that. You'll also be doing an analysis of an acceptable use policy as well. We give you background regarding that. What is Michigan's compulsory? First of all, what's compulsory attendance? What's that mean? Compulsory attendance, that's the ages in which students are required by law to be in school. Now, I never can keep it straight. In Ohio, every state's a little bit different. In Ohio, I think it's 6 to 16. I'm not sure. Does anybody know what it is in Michigan?
It's also 6 to 16.
Yeah.
Yeah.
That's kind of the most common of all of them. Although I've seen some go as low as 14. I've seen some, I think Pennsylvania was the weird one. Pennsylvania, it was like 8. And I went, okay, whatever. Okay, so this is, in today's world, this is extremely important. Acknowledge the lawful requirement to educate illegal migrant students. We have no choice. No choice. You know, I'm probably going to go. I'm going to go a little bit political here. I don't mean to, but I'm sure you heard about the Springfield, Ohio situation. Springfield, Ohio had about 40 or 50,000 residents. 30,000 Haitians were brought into that community. Can you imagine in the school system? Now, I don't know how many of those students or how many of those individuals had children in school, but can you imagine the drag on that school system? We're also required to teach them in their native language. Wow. And no federal help on this. None. The school system has to absorb this, and you folks that have had school finance will understand. You've got to absorb this with your local taxes. My heart goes out for that Springfield superintendent because, oh my God, that is unbelievable. Homeless children and that I kind of I'm okay with that. Homeless children, illegal children, they show up at your door. You have to educate them, no questions, in their native language. Oh my gosh. Okay, enough of that. Obviously, recognizing the differences between excessive absence, tardiness, truancy, excused and unexcused absences. Oftentimes those are pretty well spelled out in your handbook, the student handbook, so that people know exactly what those are. They deviate a little bit from state to state. I never can remember exactly what states there are. I will just go into one of them. In Ohio, we have the typical, dental appointment, medical appointment, blah, 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 blah. And we have emergency or other set of circumstances in which the judgment of the superintendent of schools constitutes a good and sufficient cause of absence. I was in a very rural community. It was a very common practice for deer hunting. And schools never knew what to do with it. I mean, it was like, what do we do with this? And finally, I just said, let's quit fighting this. let's consider, it's in my authority as a superintendent, I'm going to consider this other set of circumstances and that it's going to be excused. Some people didn't like it, but that was fine. So anyway, the other one that this kind of set into, and I had a unique way to deal with this, was parents oftentimes don't know when they're going to, or they have very little decision on when they take their vacation. They might take their vacation during the school year. Well, many staff members would get up in arms about this, and the kids is blah 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 blah, and we can't let it happen. And I'm going, my God, the parent is entitled to a vacation. It's during the school. We want to promote family unity. Therefore, let's make this make sense. And so I excuse those kinds of circumstances as well. Some faculty didn't like it, but I didn't care. So the next one is Family Educational Rights and Privacy Act, another very important one that you should have some awareness of. The first information in there is directory information. And, Carissa, you're shaking your head. Can you tell us what directory information, what that means in FERPA?
Sorry, I feel like I'm going through all my things.
That's okay.
Such directory information includes information such as name, address, telephone listing, date and place of birth, participation in officially recognized activities and sports, and dates of attendance.
And schools can disclose that information.
Yes.
No, well, according to FERPA, schools have to give parents the opportunity to opt out of that information, typically with a letter. Most parents don't read the handbook, so therefore they don't do it. And so therefore, it goes on as is. Whenever I've had individuals kind of question me on this, I always kind of chuckle. And I said, I used to coach. And I said, one of the things that we want to provide our super scholar athletes is how quick they are, how big they are, how maybe how much weight they have, whatever. And it's a good thing. So you're against, letting the school release that? Oh, well, no, that'd be okay. My kid gets a scholarship. Well, the same thing is true of the other stuff as well. Okay. So the keys to FERPA, and of course, it is to protect the rights, particularly of the records of students. Basically, here are the keys. Who may see the record? Now, I've been out of schools for a while, so when you go into a student file, do you have to sign a form saying that you're looking at the student information? Does any of you have to do that? It's kind of a good idea to do that. I kind of started schools in Ohio to start to do this. Here's the reason. So I always like to give this particular situation. So two teachers in the school system. One teacher has this nasty boy, and there's this other teacher that has this lovely girl. The boy and the girl are going together. The teacher who has the nasty boy looks at his record and finds out information. Does the teacher, without the authority to get in that student's file, have the authority to get in there? The answer is no. No. Now, once again, you ain't got a problem till you got a problem. So nobody's probably going to ever question that, but yet it is something to keep in mind. So only school officials with legitimate reasons, educational reasons, should be looking at those files. Another student intending to enroll, yes. State or local authorities can do that as well. And of course, parental rights. They have the right to an annual notification. They can opt out of the directory information. They have the right to inspect and contest the contents up to 18 years of age. I always find it interesting because college students don't have to let their students even know what their grades are. They don't have to. Now they can allow them to, don't have to. Non-custodial parents have the right to information. Non-custodial parents have the right to the information. And that's kind of important. I'll leave you with this story. I had a very interesting one. Had a student who was being expelled, and there was a non-custodial parent in another state. There was an attorney involved, so I knew this was a big deal, and I kind of knew that they were watching me to see if I would foul up. Well, I knew the law. I knew that that non-custodial parent had the right to all this information. And so therefore we did a conference call where they heard all that information. And I could almost see the attorney wither as this was going on, because that was going to be the whole, I thought there's a whole, that was going to be their case. The last one, this is always astonishing. Of course, in today's of technology and maintaining records electronically, it's not a problem, but 100 years, you got to keep records for 100 years, according to FERPA. One last story. So I was very knowledgeable of FERPA early in my career because I was a guidance counselor. And I had an individual who asked to see their record, and they graduated in 1939. And I'm going, holy crap. I wonder how good our system is. And it wasn't electronic. And of course, today's world, it's probably easier to pull up. And I dug through that stuff, and by George, I found it. And I went, whoa, I can't believe this. Now, I don't know what would have happened, if I'd have said, well, it got lost. Probably nothing, but, I didn't want that. I didn't want to have to go there. Are there any terms you need explained?
I actually have a question about FERPA.
Oh, okay.
And this came up in a school that I taught in.
Yes.
We had a student who was under protection by the FBI against her dad, who was threatening to basically send her back to her native country and marry her off. In that situation, would the dad have the rights to her information?
Okay. So one of the things you're going to, this is a great question. And I think this offers me an opportunity to give you some learning, a practical learning situation. There are situations that you, even as a superintendent, you are best advised to consult with other experts, school attorney, for example. So in general, I would probably, in that situation, I would probably be inquiring with the school attorney to see if they could give me advice. My gut feeling is non-custodial parents have every right. And so unless, good point here, unless there's a court order that says they don't have the right. If there's a court order that eliminates that right, and some court order, some separation or divorce decrees had that information in it, and so therefore that my first step would be want to investigate that information, see what is said. Now, if it's moot, silent, you have to fall back on the law saying that they have the right. But once again, I would sticky situation, I would probably at least do some consulting. Now, once again, I'm not an attorney. And so curbside opinion, I guess is what I give you. Okay. So, by George, 55 minutes. I didn't do too bad. I was a little bit concerned about going through those cases. Questions you guys got? And once again, you guys are on point. I feel ecstatic in the way you absorb this information and the terms and those kinds of things, because once again, I can't stress enough how important these sections are, these modulars are. The next one, spatial education, is equally as important. It's equally as important because of the kinds of things that we deal with in schools. So with that, last questions, I think you're pretty well prepared.
I did have just one question as
Yeah.
I was reading through the student searches the other week. And it mentioned that, law enforcement can be present or your school officer could be present, but they can't lead. And I was just curious, has there ever been a ruling on, and maybe I missed it in the materials, what constitutes them leading? Like, can I ask them?
I love your question, and I wish I would have mentioned this before. It is a very good question. So schools have resource officers, and so you have a law enforcement person in building already. So, and I've had this happen before. I've had individual principals have to have guts. Okay, you have to have guts because you're leading the school. Okay, and I've had individuals who have told me in searches, well, I'll just let the resource officer do it. There's one problem with that. They are required by law to have a search warrant. The school doesn't. Therefore, in direct answer to your question, Ezra, as the school official should be the one who unlocks the locker, who gets into the locker. It's always good to have a witness. Okay, we don't have body cameras on us, but it's always good to have a witness and have that resource officer behind you. Okay, but if it goes the other direction, they are required by law to have a search warrant, and they probably should know that, and probably would know that. They might not feel comfortable in telling the school administrator, no, you lead the charge, but that's the way it is. Okay. Hi, Lenise. Good to have you here. I understand. I mean, I realize that you probably had something going on. I did record the session, so you'll be able to pick it up on a recording. Okay. Great question, Ezra. I should have mentioned that because that's that's key in today's world for sure.
Just a quick follow-up on that. I'm sorry to
No,
keep
that's
over here.
no,
So like our school's resource officer, because we're a private Catholic school, he was formerly in the FBI. So like he has all the keys, everything goes through him. And so he's the only one that has like the locker key. So if I was the principal in this case, I could ask him, hey, I need this key. And as long as I'm the one opening the lockers, as long as I'm the one doing it all, then I would be okay.
I'll tell
As
you
long
what,
as he's not the one physically opening it.
you're really getting into another key real life
Right.
situation. There's politics. This cop might not know school law. This cop might be gung ho. This cop might think they control the world. That's why the principal's got to have guts. You have to say, no, stand down. You can be, yes, I need the key. Now, to be honest with you, I don't like that policy. I don't like them having that key. Maybe there could be two keys, but to have them having total control, I don't like that. I mean, that's just me. The school should have control of the school, not the resource officer. The principal is in charge of the school, not the resource officer. they play a very important role, and I don't want to step on their toes, but I also, we should be educated about school law. They probably aren't, especially if they're first or second year resource officer. Maybe if they're a 10-year resource officer, they probably have learned through the process. But once again, you ain't got a problem till you got a problem. You know, so yeah, the resource officer opens it up and they find stuff and they suspend the kid, and you know, the suspension goes on, and no harm, no foul. You ain't got a problem. However, that kid that has an attorney as a parent, oh, you might have a problem. Okay. Well, I am I just can't tell you how excited I am. You know, we had a bit of a lull there, and I knew how critical this stuff was. And I even did a switch up on the assignments to make sure that these others, the case study and the discussion, follow this, because before I had it reversed, and that ain't good. We have to, you know, set that up that way. So, other questions, or anybody need to talk? With that, have a good one.
Thank you.
Thank you.
Good luck on your quiz.
Thank
Thank
you.
you.
Bye-bye.
Thank you.